Welcome back. And of course, it's time to talk about the issues of the day. And it has to do with a lot of legalese, as I said. Two judgments today. One from the Court of Appeal sits in Abuja, where the judge held that the decision by the State High Court, Justice Charles Wale, that ruled against Mr. Martins Amewule in a suit brought against him by Victor Kojombo, the two gentlemen who are battling over who is the authentic Speaker of the State House of Assembly. The judge ruled in favor of Amewule in that particular case, based on the fact that it's more like a judicial overreach. That's what we'll talk about today, as well as the issue in Edo State, where the court has also said that the primary election of the PDP, indirect primary held by the PDP, has been nullified because certain persons who are delegates were not included in that exercise, and they are believed to be loyal to the former or the impeached Deputy Governor of Edo State, Mr. Philip Shaibu. That's why we're being joined in the program by Senior Advocate of Nigeria, Mr. Wahab Shittu. Mr. Shittu, thank you so much for coming on the program.
Thank you for inviting me.
So, Senior Advocate, let's start from 1 to 2. Let's start from the Rivers case, which is the latest before we get to the Edo State case. I wonder what you make of that particular situation, because we've all been waiting for this particular judgment because the court has reserved judgment. In that case that was decided, though it was an ex parte granted, restraining the Amewule group from parading themselves as both Speaker and members of the House, and now they appeal, and now the court has said the lower court was wrong. I want to, maybe your first impression about that particular case.
Well, it's a judicial issue. Yeah, the court of appeal took that position after a careful interpretation of the relevant provisions of the law, including constitutional provisions, as to the court that has jurisdiction to make such a pronouncement. And the court came to the conclusion that in this case, it is the Federal High Court that is entitled to make such a pronouncement, and that the High Court lacks jurisdiction to entertain the matter in the first instance. So orders made by the High Court were judged incompetent. So the status quo ante bellum resumes. So until that, the Court of Appeal has sustained as a rule that, as far as that subject matter is concerned, it is the Federal High Court that has jurisdiction, that the State High Court does not have jurisdiction to entertain the matter. I think let's leave it at that.
So are you saying, by implication, that this was more of what I'll call a judicial reprimand for jurisdictional overreach?
Yes, that's what it is. The Court of Appeal has clearly ruled that the lower court that entertained the matter lacks jurisdiction. And when the court lacks jurisdiction to entertain a matter, whatever orders it makes is a judge incompetent. And that's what the situation is as far as that case is concerned.
So what will now be status quo, whether it's antebellum or status quo? Because the substantive issue was that they approached the State High Court, which doesn't have jurisdiction, by this decision of the court to say, this gentleman defected, so they do not qualify to be members of the House. Their seats are vacant, and an ex parte was granted. So now that it is like this, who do we say is the Speaker of the, by law? Because you're the lawyer here, so you help us make sense. I don't like to make assumptions.
Well, by law, the party, the status quo before those who went to court, before the lower court went to court, is the status quo to be recognized. So what the Court of Appeal has said is that the holding of the trial court was erroneous. So the status quo remains what was operating before they went to court.
Leonard, sir, I'm going to bother you a bit on this because I have the prayers of that particular case in my hand.
Okay.
Although I haven't seen the CTC, I don't know whether the CTC is ready, but we haven't gotten the CTC or the reasoning of their Lord Justice.
It is more useful,
yes,
to comment on
the reason
on judgment of court after citing the certified true copy of the judgment.
Yes.
Or after going through the judgment and also going through the record of proceedings, including the processes. That will make you to be able to make informed commentary.
Okay.
Yes.
Just for the sake of just making comment on this particular issue,
Okay.
given the fact that the court has now said you do not have jurisdiction,
yes.
You didn't have any
yes.
Reason to even entertain this case.
Yes.
I want to read to you some of the prayers that Amewule sought and what this now means based on those prayers.
Okay.
An order restraining Okojombo from parading himself as speaker and others as well. An order, which is the 10th prayer, an order setting aside purported meetings, sittings, proceedings, or deliberations of the assembly presided over by Okojombo with only 2 members in attendance. The 11th one is interesting. An order setting aside all actions, steps, decisions, and all resolutions of the purported assembly presided over by Okojombo. Okojombo has presided over swearing in of screening of commissioners and screening of caretaker committee. Does this judgment nullify all of that?
Well, if the court that entertained the matter, the lower court is then said to lack jurisdiction, it means that we return to the status quo ante bellum. It means that all these prayers purportedly setting aside all these actions remain null and void for now until you approach the appropriate court. The court has not made any pronouncement on these reliefs because the Court of Appeal is saying the court that adjudicated on these reliefs lack jurisdiction to entertain. There should have been in another forum, not that court.
Okay. Just for the purpose of our audience, if my producer can put up the 10th and 11th prayers, I want the audience to be part of the conversation so that as I engage, if we can get that 10th and 11th prayers of Amewule, where he sought relief of that particular cause. So that's it. I just wanted the audience to see what I'm talking about, not just reading. So I wanted to find out from you. So let's go to the 11th one, if we can, so that your intervention, which I sought to be able to be sure, because whether everything they've done is nullified. But when we see the CTC, we'll be able to make sense. But before we move on to the issue of Edo State, one more question, Leonard Silk. A judge, what will give a judge the right to preside over issues that he has no jurisdiction over? Because the Constitution is very clear in Section 272, I think so, or subsection 3, that it is only the Federal High Court that has the power to make the pronouncement. Although they did not make pronouncement on some substantive issue, they granted an ex parte. So is there a condition that the State High Court can grant an ex parte for an issue that the Federal High Court is supposed to preside over?
When a court lacks jurisdiction to entertain a matter, that the implication is that that court also lacks jurisdiction to make any order, whether it's party, interlocutory, or final. What it means when they say a court lacks jurisdiction, that it lacks the powers to entertain the matter. It is bereft of any judicial powers to entertain that subject matter. You know, jurisdiction of a court is defined by the subject matter of the action. And the subject matter of that every court is entitled to adjudicate upon is spelled out. Some courts have, concurrent jurisdiction. There are matters that you can litigate at the level of the Federal High Court and the High Court concurrently. We are talking of fundamental rights enforcement actions. Either of those courts can answer. There are matters wherein a court has only a particular court has original jurisdiction. You are talking of disputes between states and federal government, and disputes between states and states. The Supreme Court has original jurisdiction. Okay. That's the only court that can entertain it. That's where you can commence the action.
Okay.
Now, there are also situations where certain courts are vested with exclusive jurisdiction. Labor-related matters is vested only in national industrial courts.
Yeah.
And there are some other matters exclusively reserved for the Federal High Court to entertain. I'm talking of matters enumerated under Section 251 of the Constitution. Only the Federal High Court retain the exclusive jurisdiction to entertain those matters. So when you go and commence those matters in the High Court, you are just wasting your time. You are wasting valuable judicial time. The action is incompetent. And when an action is incompetent, it means that the court lack jurisdiction to entertain the matter.
Let us say I ask that question deliberately because something is playing out also in Kano State, where it's an issue of whether this has jurisdiction or the other. So why would judges entertain cases they don't have jurisdiction over? That's actually my question.
Well, that is, with due respect, that's a gross example. I mean, an example of judicial rascality. You have no business delving into matters in respect of which you have no jurisdiction. Because the implication is that as a judge, you should know. Judges are the repository of legal knowledge. They are the custodians of our laws. They swear to an oath to observe the tenets of our laws. They are not supposed to act in excess of jurisdiction or outside their judicial powers. And most judges know this. They are presumed to know. So when a judge deliberately sidelines the Constitution, constitutional provisions, and statutory provisions, and has to assume jurisdiction over a matter in which clearly he has no jurisdiction. Right. My view is that that's an exercise of judicial rascality. So in your but there are remedies for that. Okay. That is why we have appellate courts. Okay. To be able to say, okay, what you have done is wrong.
Let us say, yes. We'll jump to the issue of Edo State, but yet again, maybe for emphasis, who is the Speaker of the House now?
The Speaker of the House of
Rivers State House of Assembly. Am I putting you on the spot here?
You are putting me on the spot because the names of particular individuals.
Ame Wule is the one that got this judgment of the Court of Appeal in his favor.
His favor.
Oko Jumbo is the one that got the judgment at the lower court that has now been overturned.
Yes.
So who is the Speaker?
Well,
in the eyes of the law.
The one that has been overturned is not the Speaker. Okay. It's not the Speaker. You see, when a pronouncement is made by a court, rightly or wrongly, it still remains the law. You were mentioning the fact that when a court exercises a jurisdiction in a matter in which it does not have jurisdiction, it doesn't mean that exercise of jurisdiction is void automatically. It has to be set aside by a superior court, because a court has jurisdiction to be right as well as jurisdiction to be wrong. So if, as a judge, you exercise jurisdiction over a subject matter and make pronouncements in respect of a matter in which ordinarily you should not have jurisdiction, that pronouncement is not void. It still remains valid until it is set aside by a superior court. Okay. So even though it is wrong, you can only
set aside.
First.
Okay, first. No matter how illegal it is. Okay, let's not move to Edo State. I want your quick, maybe your first impression of this outcome. They conducted a primary. It was a very contentious issue. Even before the primary, there were 10 of them, I think so, and eventually Mr. Aso Ighodalo emerged. But we had a parallel Congress somewhere in another location outside Samuel Ogbemudia Stadium. But now the court has said, for excluding a particular number of people, about 300 and something.
78.
78. Whatever he did at Samuel Ogbemudia is nullified. Your take?
You see, in making a comment, I have to preface my comments on this matter by saying that I'm yet to read the full text of the judgment. I don't know the processes filed in the case. And I've not also cited the record of proceedings. But looking at the law, what the court has said is that there's a case of wrongful exclusion of 378 delegates here. And because these 378 delegates were excluded, the entire primary is void. And that there's no primary. That's what the judge has ruled. Yeah. Now, the question you want to ask yourself is this. When was this suit filed? Was it filed after the primary? Or was it filed before the primary? What I found out, in my random checks revealed that the suit was filed on the 8th of February, 2024, while the primary itself took place on the 22nd of February, 2024. So it means that the suit was filed even before the primary. Now, the next question is, who filed the suit? Delegates. Whether delegates are competent by law to challenge the outcome of a primary.
That's another issue.
That's another issue. Now, the authorities we have, if you look at Section 84, subsection 14 of the Electoral Act, it says clearly that the outcome of a primary can only be challenged by the aspirant. Any of the aspirants can challenge it. And then if you look at the case of Osage versus Enogama, Osage versus Enogama was a case decided by the Supreme Court in the year 2022. And what that case decided is that delegates do not have local standard to challenge the outcome of a primary. That the only person who has the local standard to challenge that a primary conducted is the candidate. And that decision is consistent with the provision of Section 84, subsection 14 of the Electoral Act. So now every court has jurisdiction to expound its jurisdiction. Every court can expound it, but no court has the jurisdiction to expand its jurisdiction outside the broad letters of the law. Now, whether that judgment pronounced upon by his lordship Echo can stand on appeal remains to be seen, because delegates clearly instituted that action. And by law, the law stipulates that delegates they are not competent to challenge the outcome of a primary. I'm not the one saying that. I'm reading to you the clear provision of Section 84, subsection 14 of the Electoral Act 2022, which says only an aspirant in the primary election has the local standard to approach a federal high court to complain about the outcome of a primary.
Let me read that provision. Notwithstanding the provisions of this act or rules of political party, an aspirant who complains that any of the provisions of this act and the guidelines of a political party have not been complied with in the selection or nomination of a candidate of a political party for election may apply to the Federal High Court for redress.
Did you see delegates there?
No. So what
is there delegates there?
I'm not arguing. I'm saying this is the extant law.
Yes.
And you cited a case law as well.
The case that I cited is Osage versus Enogama, which was decided by the Supreme Court.
So there's both a precedence and an extant law.
Yes.
What was now the reasoning of the judge?
That is why I said I will not stand here and condemn the judge without seeing the processes and looking at the justification for his reasoning, for his conclusion. Until I'm able to see the justification for his conclusion, as well as read the judgment in full, I won't be able to condemn what he has said. But looking at the broad letters of the law, it raises jurisdictional issue. The jurisdiction of the court in matters of nomination is very narrow. It's limited to a situation where an aspirant is aggrieved by the outcome of the primary, an aspirant in the election. And then Enogama also ruled that delegates have no local standard to challenge the outcome of a primary, except the facts are distinguishable. I'm inclined to believe that it's a matter that will be resolved by the Court of Appeal.
I know we've almost... I don't want to use a strong word because we have to respect the honorable justices. Let's also talk about your colleagues who also know that there is an extant law and there is a case law that precedents that showcase. How come they also pulled this off without necessarily, didn't they see this before, or why could they have taken this to the court?
You see, every case has its own peculiarities. You can distinguish a case on the index of facts.
Okay.
Or you can also distinguish a case on the index of on the basis of the circumstances. You could also look at some other factors, because when a decision is handed down, it is handed down based on the peculiar and the facts of each case. I have not seen the reasoning or the justification of his lordship Honorable Justice Eko. Now, I have a lot of respect for him. I've done a number of cases before him, and I know he's a very sound judge. So he may have his justification for it. But I'm saying that this case has definitely raised issues of jurisdiction.
Okay.
It has raised some other issues of whether of local standard.
Local standard, yes, as well. Because
and then those are interesting issues that will be litigated at the appellate court.
Let's say it means that it's not Uhuru yet for those who are celebrating.
Yes, it's not Uhuru. Either side, it can go either way. That is why you see. Let me make this clarification.
All right, in rounding up.
You see, a judge sitting as a judge can't make mistakes. Because a judge sitting alone as a judge can make mistakes, there's the mechanism for an appeal to the Court of Appeal, where you have 3 justices who can look at both errors of facts, or misdirection based on errors of facts, or misdirection based on errors of law, or misdirection based on errors of misfacts and law. That you will find out at the Court of Appeal. We have 3 justices are sitting. And after they look at it, if you are still agreeing, we can still go to the Supreme Court. We have 5 or 7 justices can look at it, depending on the nature of the case.
So clearly we're talking on the River side, jurisdictional overreach.
Yes.
On the Edo side, local standard.
Yes.
Dennis Silk, we must thank you for your insight as always on the program. Thank you so much.
It's my pleasure. It's my pleasure.
Senior Advocate of Nigeria, Wahab Shittu, bringing insight to the conversation. Thank you, sir.
Thank you.